Hello, it's Tuesday at 2 with Chip Merlin, and thank you very much for signing up. We have I think it's going to be a pretty interesting, if you like nerdy insurance type topics, a pretty interesting discussion this afternoon. I was trying to focus in on time traps because time traps are just what I call killers to coverage. They are unfortunate things that go on with respect to when you have to do things, and if you don't do it in a certain amount of time, the next thing you know, you can have full coverage, and then you don't have any coverage whatsoever at all. And that's what we're going to talk about today. With me is Larry Bache, an attorney with the Merlin Law Group, and I'm Chip Merlin. I guess I should always introduce myself. For everybody, I guess I have to tell them that there is a PowerPoint. And how do they get to the PowerPoint, Larry?
Yeah, so this PowerPoint presentation is extra important because it is a little bit more state specific. The laws are very important. A lot of statutes, a lot of case law in here that we're going to go through today. But it is going to be posted by Megan and Justin on the feed. So if you look in the comments section, there's going to be a link to the PowerPoint presentation. We have some introductory slides, and then we're going to start up on slide number 6, Chip.
Oh, so
which is your introduction.
There's my introduction. There's Tuesdays at 2 with Chip Merlin. That's what my hair normally looks like, but I haven't had a haircut in about 2 months. But this is going to be the last show that everybody's going to see what I used to look like when I was probably a freshman and sophomore in college with just my hair growing out the back. It's dippity-doo-dah because we've opened up the salons, and tomorrow I finally get, tomorrow afternoon at 12:45, I get to finally have a haircut for the first time in 9 weeks. So, but
I got my haircut.
You got yours, probably illegally.
I don't know what you're talking about.
Yeah, So, I keep going through. If you go to the third slide, you have my information and how you want to get in touch with me. I have no problem taking text messages or emails from people. Actually, as we go through this, I want to invite everybody. If you have a question on anything we're asking, please write a question in. We're going to leave enough time at the end of this to answer questions. As a matter of fact, last week all we did was do questions on this stuff. And there's Larry Bache's office number and email. Why are you afraid not to put out your cell phone number?
I don't know.
You want to tell everybody, or you're chicken?
Sure, 813-344-6735.
He's really chicken, but I baited him into it, so there you go.
We're gonna fix that, Megan, next week. We're gonna make sure my cell phone number's on.
He don't want to be chicken compared to me is really what it is.
That's right.
I'm gonna be showing up. So we're gonna talk about the time traps for being late, and we're gonna talk about the 4 different spots. So this is on slide 5 of 5. Gosh, 45 slides. Time traps for being late. Notice of a loss, proofs of loss. Actually, repair stuff is in there. We talk a little bit about, although we're going to talk about that fully in 2 weeks.
Yep.
And then the statute of limitations. Oh, and this Friday at 2 o'clock, proofs of loss. We're going to go through a series where over 4 weeks of Corey Harris. Corey, 11 years ago, wrote a blog deal about proofs of loss and everything you want to know about notarization and stuff like that. I'll give a shout out to Cal Spoon, who has a class teaching public adjusters, and one of the public adjusters came out saying something about notarization was not quite right. I think maybe she wasn't the best student, or she was a great student, I don't know. But Corey and I are going to go through all those because it's a pretty important thing in some states regarding proofs of loss, actually in almost every state about proofs of loss, getting it right, and that's a whole separate topic that we're going to go through starting this Friday at 2 o'clock for about a half an hour, and that'll go for 4 weeks, is trying to educate everybody. But if you go to number 6 of 45, notice of loss, the first thing is, hey, when do you have to provide the insurance company with notice of loss? And I go to slide 7, and this is the general rules. Usually if you read the insurance policies, always read the insurance policy. Read the full policy, RTFP. And usually every single loss will say is, promptly provide notice of loss or as soon as possible. And I've noticed a lot of people talking about both insurance agents as well as sometimes other attorneys in their blogs. If you read the policy, it doesn't say you have to give notice of your claim. It says you have to give notice of your loss. So just give notice of the loss. As a matter of fact, sometimes there have been discussions, I've heard some agents, and it goes back and forth, whether or not you have an obligation to provide notice of loss, even if it's not greater than the deductible. And some have argued you're supposed to do that because that's part of the policy conditions that you have with the insurance company. Whenever you have a loss, you're supposed to notify them. Some others are saying, are you crazy? Because it's going to go down on your
Yeah, and your
thing
claim
of having a
history.
loss in your claim history, even that's less than the deductible, and some insurance companies don't like that.
Yeah.
But, do you wanna talk about that?
Yeah, so I think a lot of people, if you go to the next slide, this is examples from the different policies we pull, the ISO forms as to what's required for prompt notice. But a lot of people ask, well, what does prompt notice mean, or what does as soon as possible or practical mean? Uniformly across the country, it is a reasonable person standard. And so it's under the specific facts and circumstances of the claim as to what constitutes a reasonable notice. Is when the policyholder knew or should have known. From a legal perspective, that's very important.
Well, that's in those states if it says knew or should have known versus you have an absolute obligation to go no, even if you're not around.
Right, but I think that uniformly across the jurisdictions, it is known or should have known, or under the circumstances, what is reasonable. And so it's not just a one size fits all. That's why sometimes you'll see case law where there's a 5-month delay and a court or a jury found that was late notice, and I see a lot of my defense attorneys kind of misuse that law. Or if we've got a case where there may be 2, 3, or 4 years, like in a state like Arizona, it's the idea that, oh, it doesn't matter, it's when they knew or it's when they found out. So I think it's important that we understand it's very fact specific, and that helps us from a summary judgment standpoint as well, obviously, for the lawyers.
If you go to slide number, I guess it's number 9, where it says notice of loss, and I wrote this out specific, oh, did I skip Florida? No. Notice of loss for number 9, the 45. Sometimes you read these insurance policies and they say the notice of loss has to be in writing. Make certain that there's something in writing going to the insurance company. Often what happens is the notice is provided to your agent, who then fills out typically an accord or notice in writing that goes to the insurance company after they take it from you, but something gets in writing to the insurance company. But there are actually some cases out there that talk about there was no notice in writing given to the insurance company. Read the full policy. If it takes in writing, I literally tell people to start writing it out somehow and get it to the insurance company in writing and not just oral notice. So again, if we go to page 10, follow the policy language about how to give notice. Typically most people call their insurance agent. They provide them what the notice is. I had a loss. Insurance agents can ask certain questions. Typically, I tell everybody follow up in writing. You know, an email can be in writing, but it's not proved delivery. But, you know, hey, I provided you this notice of loss. You're going to provide it to the insurance companies, my understanding, you know, just to follow it up. So there is a record that actual notice of loss, you know, has been given or was requested to be given. And sometimes if you do have to have it in writing, and I often tell people what the best practices for delivering things is actually make sure they get delivered. I don't necessarily think certified mail in this day and age is the fastest. It's going to sometimes take 2 weeks. The person who's supposed to receive it's not there. Next thing you know, it gets sent back to you. It never got delivered to them. There was an attempt for delivery, but it actually didn't get delivered. And so overnight, boom, delivery right there by Federal Express, US Mail, UPS, something like that is proof that somebody got delivery to it. So that's what I try to use right now, and I often tell people sometimes it's a lot cheaper than certified mail. So I don't know why everybody always use certified mail, but unless it says certified mail, which some things might require, I haven't seen it too often. It just says it has to get delivered.
Slide 11, we got the Arkansas Insurance Department Bulletin, which was your blog from May 8th.
It was,
2020.
and somehow I just switched from our.
Sorry. So this blog is really important because we had.
It's a great blog.
It's a great blog, but I think
If you keep up with our blogs, you'll keep up with what's going on. Most people didn't know that they had this bulletin like that.
right. So you want to definitely access this bulletin.
Larry Bass says, "Oh my God, I just read your blog. Don't you read it every day, Larry?" No, Chip, I don't read it every day. This is a great blog.
Yeah.
This could help us a lot in our Arkansas cases.
Well, this will help, I think, all over the country because it really kind of Arkansas had a problem, and their Department of Insurance realized that insurance companies were denying claims for late notice. And they actually came out with a bulletin, and it says Arkansas Insurance Department residents have been denied coverage under their homeowners policies for damages caused by the peril of windstorm or hail. Many of these denials are due to the insured's failure to report damage within the time period required under their policy. And this is important. It says, due to the fact that it is often unreasonable, and I wish I could read this in front of a lot of these judges, due to the fact that it's often unreasonable.
I
to
know
expect-
everybody right there watching just loves to listen to you read all this.
Well, it's
but
important.
Go
You gotta
ahead.
look at it. Yeah, unreasonable to expect the homeowner to identify wind or hail damage within the time period specified in the policy. It is the position of this department that a period of 365 days must be allowed from the date the insured discovers or should have discovered the damage from wind or hail. And it goes on to say that we have a 6-year statute of limitations, and insurance companies, you're not gonna be denying claims within that statute of limitations if you don't actually do an investigation just based on late notice. And it's a great bulletin for that, and it really kind of you hit it on with your title, is that, hey, you're not expected to climb on roofs to see damage. And so, again, it goes back to evaluating the claims as to when the insured knew or should have known. If they've never been on the roof for 9 months, and then a roofer comes out and tells them you have damage, this bulletin says insurance companies don't deny those claims. That's not untimely notice. It's a very good article.
And so I kind of pushed it to the limit. I said, you know, is it really the insurance company expects its customer, all of its customers, to be able to climb up ladders? You know how many people actually ever climb up a ladder?
I don't like
Not that many. Do you know how many people climb up ladders and get hurt? A whole bunch. People climb up on roofs. Even insurance adjusters that might be watching this, you gotta comply with OSHA standards when you go up there. And some people ask me, why do insurance companies who are publicly traded that have an obligation to follow federal law have all their people using ladder assist and all that? Could it be that they don't wanna pay for their own adjusters to go up there and put the fall protection that they're required to under OSHA? Maybe, but they go ahead and let ladder assist people do it and fall down all day long too. But, you know, we don't want, you know, we're digressing a little bit, but the truth of the matter is, it just kinda makes sense, especially with hailstorm claims. Oh, we're gonna have a special thing next week for notice requirements and statute of limitations for all the hailstorm states and all the hurricane claim states, just because it seems to be so important to so many of our viewers.
Yeah.
And so, and there's so many of them, and it's state specific. We're gonna break it down state by state for the hail damage claims states. I guess Texas and Florida and
Nebraska,
a number of them are
Colorado,
both,
Oklahoma.
you know, but
Yeah.
for both hurricanes and all that, so that you gotta know those rules in those states. And if you're an adjuster that goes around, or if you're a policyholder in those states, we're gonna address those next week at 2:00. So I hope you're back for that. But I you know, one of the reasons I wanted to talk about what we're doing here is because I saw the statute, this bulletin come out. We have a law librarian in our a law firm, Rupp Domenico. He's just a great asset to our firm. He's a lawyer that went to law school, then he also got a law librarian degree, and so he keeps up on all the changes, the bulletins and things like that, that it's don't magically come popping up to us, but we actually dedicate part of our law firm so that these lawyers, if we would have them read more, would keep up on all of our cases. But theoretically, we're reading and keeping up all the time, and so that we can use the cutting edge to our clients' benefit. And Larry's absolutely right, that bulletin, while not law, because it's not a regulation, it's not statute, it's not case law, at least can be persuasive with respect to what a policy might be in a specific state. And actually, if we do this right, as we try to argue to other departments of insurance, NIC meetings and things like that, I'm certain other regulators are not gonna wanna have their 85-year-old ladies or people who might not be as physically fit as they used to be. That might be me, as we get older, which might be me. Trying to climb up ladders and pitched roofs and things like that, because it honestly is extraordinarily dangerous. Most people, for hail damage claims and even hurricane claims, goes through, they don't see any damage, they're not gonna be climbing up there. They don't have a ladder to climb up. If they did, they're afraid they'd fall off. Most people simply just are not agile enough to go up, and if they don't feel any raindrops dropping on their head inside their home, they're not making any notice of the loss, because they don't have reason to believe it is. And this is sometimes where we then get into the
facts are
lawsuits,
important.
right,
And you
because then
guys-
there's delay, so.
And public adjusters and contractors, they hear this all the time. They hear, when the insurance companies make these arguments about, hey, it's been 9 months, it's been a year and a half. And obviously you guys know that, hey, it didn't start leaking right after the storm or with a hurricane. It can take, after Florida, once you get into October, November, and into May, actually, you don't have a lot of rainy days if it's not a hurricane. And a lot of times these storms lead to leaks that occur later on. And it's an ongoing battle that you guys deal with every single day. And so the next slide, which I want to talk about, is slide number 12 and 13 and 14. They all kind of go together.
So Larry's gonna talk about the traditional rule,
Yeah.
the
notice prejudice
Notice
rule.
prejudice rule, what's the last one?
And then the notice prejudice rule with rebuttable presumption of prejudice. So there's three rules when the courts are viewing an occurrence-based policy as to whether or not the insurance company has a right to deny the claim for late notice. And the first standard, which is the oldest standard, is called the traditional rule. And as the slide states, it basically that regardless if there's any prejudice at all, if the notice of the claim is late, the insurance company has a right to deny the claim. So the only burden is on the insurance company to prove that the notice was late, all right? And then the second rule, which is a more common rule, this is the majority rule, is a notice prejudice rule. And now the insurance company has to prove two different elements if they're gonna deny a claim for late notice. Number one, that under a reasonable person standard, the notice was late. Number two, they have to prove their investigation was prejudiced. And this map is fantastic. Jonathan Bukowski actually put this together for us at our map deal last year, okay? And he actually goes state by state for these three slides. So please access the presentation on the link right there. Download these three slides because it's gonna answer a lot of your questions. But the notice prejudice rule means even if notice is late, as long as the investigation was not prejudiced for the insurance company, they have to pay the claim. Because the idea is insurance is there to pay. That's the whole purpose of insurance. The third rule, which is the minority rule, is a rebuttable presumption. Now, Florida is the main state or the key state that has this law that we deal with. Obviously Iowa and the other states that are marked in red on this slide, number 14. And this rule is similar to the majority rule of notice prejudice, but now the policyholder has a burden to prove that the insurance company was not prejudiced. So the insurance company still bears the burden to prove that the notice was late. Then the burden switches to the policyholder, which is us, right? And we have to prove that there was no prejudice in the investigation. So in English, how does that really work? It's a jury instruction. The jury instruction is from the judge, ladies and gentlemen, the insurance company has to prove that there's late notice. If they prove there's late notice, then Mr. Bache and his client, Mr. Merlin, have to prove that there is no prejudice to their investigation. How do we do that practically? We get weather experts, we get engineers, and we get testimony from our clients. So those are the three rules across the country that you have to evaluate the notice and the different standards that apply.
Yeah, I did notice when I was taking a look at this, if you're in New York and wondering what the New York rule is, it doesn't say it's gray in all three of them, so we'll talk about that next week. But since I practice up in New York follows a traditional rule with some certain exceptions and things that are important that have helped us get around on a few of those claims, especially after Superstorm Sandy. But typically, I'll say this, you want to give notice as soon as possible. You want to give notice promptly. For anybody who's doing any of these, possibly thinking of bringing a business income claim for the COVID-19, the one thing universally that I can say from almost every single policyholder that's even potentially representing somebody is you ought to give the notice as soon as possible. As a matter of fact, I even saw an insurance defense attorney say you don't know exactly how these cases are going to come out. And so if a business owner wants to bring a claim, for heaven's sake, they ought to be providing notice to their insurance agent, and the agent should not be trying to dissuade them from doing so. It's an ERMI thing talking about agent E&O coverage, and this guy represents insurance agents when they get sued. So I would think if an insurance agent defense attorney is telling their agents to provide notice if their policyholders have done it and don't dissuade them from doing it, people should be doing so. If you want to make this business income claim, we'll see how those claims turn out because we're in the middle of making claims and filing lawsuits for a whole bunch of people, businesses on this. And so now, Larry, you're going to talk about, if we go to slide, where are we? Number 15, I think?
Yeah, so we're going to get some specific states.
On Florida.
These are a lot of common questions we had in preparation for this presentation. Obviously, there's some key aspects to it. You're going to have your hail damage states and you're going to have your hurricane damage states. And in Florida, there's a lot of misunderstanding out there as to what's required. We have the 3-year limitation period coming up. I want to explain what that is. So before 2011, after the 04 and 05 storms, everybody knew that Florida was a data discovery or a breach of contract claim by statute was from the date of denial or date of reporting. And it allowed the tail of these claims to kind of go further. It's 5 years from the breach of contract. So you could report a 2005 claim in 2007, and the insurance company denied the claim in 2008. Theoretically, and you could have a claim till 2013. In 2011, that was changed. Florida is a date of loss state now. That's kind of how we refer to it. It's 5 years to file for breach of contract from the date of the event. So if it's a hurricane or a fire loss or a hailstorm, you've got 5 years from the actual date of loss. If you go to the next slide, there's a special little notice requirement for hurricane claims. This is specific to hurricane claims, and it's 3 years from the date of the event. So you can't file a supplemental claim past 3 years from the date of the loss. So for a lot of public adjusters, contractors, property managers, policyholders, make sure that if you have a dispute with your insurance company right now, you need to go ahead and fully investigate the claim. Make sure you submit your total claim that you're going to present, because otherwise, if you wait until September 9th, September 10th, and you present all of a sudden a claim for windows or a replacement instead of repair, the insurance company can argue late notice, and they're going to rely on Florida Statute 627-70132 to support that position.
It's a pretty important statute that's for Hurricane Irma claims. It's coming up
September 9th,
right,
10th, yeah.
this year. So, and it applies to any parts of a claim. So you better provide the insurance company at least notice of what you're making claim for in its entirety no later than that particular date if you own a Hurricane Irma claim. So that if you find something out later, there was more damage during the repair process or something like that, you're supposed to let the insurance company know within the 3 years time limit, or they're gonna be relying upon the statute to deny your claim. So that's a big deal in the state of Florida.
Yes, that's why I think from a practical standpoint too, a lot of people ask me, do we include, code enforcement in our estimates because it's not OJET. Obviously, you need to include ACV numbers and RCV numbers. At this point, I would make sure you include and put in your estimate, it's a contingent item or it's an open item, so that they've been provided notice of the claim.
Maybe, but I would go so far as, if you really wanna be safe, I'd include everything in the kitchen sink of what you intend to be making claim for. Otherwise, there's gonna be arguments about what this really means.
And obviously, not taken out of context, you mean in good faith, that's actually warranted, and yada, yada.
And don't get me wrong, there's some insurance companies that know people are going through the reconstruction process and they don't, I've written, I gotta give them credit, the insurance adjusters don't invoke some of the statutes. They let the claims get made in good faith, the people are working, they're getting everything done. And so some of these notice issues just never give a rise to, just because in good faith they see their customers doing what I think they would like to see, and they're not trying to prevent the insurance product from working the way it is. And that's to pay the benefits. But not every insurance company's that way, and not every insurance company's gonna be that way to every single customer. You don't know. So it's better be safe than sorry on these things. In Florida, that's coming up.
Yeah,
Want to talk about Colorado, so we keep moving along?
Yeah, I just want to finish one more thing about Florida. And we're going to get into each state here that we're talking about, is can the statute of limitations be limited by the contract? And every jurisdiction is different.
But we're gonna be talking about that later.
Are we?
Yeah, there's a whole thing. If you,
there you go.
If you put this.
I did, I put it
I'm
together.
the
so-
old guy. You're supposed to
Yeah.
be able to remember stuff.
My understanding is this would be a good time, but we'll get there. So Colorado is a state that has a 3-year statute of limitations, but the policy, so notice has to be reasonable. It's a traditional state, which means, we're gonna get into how confusing it is. Colorado's kind of split, Chip. So in state court, there has not been a lot of case law on this issue, because most of the insurance companies that are litigate these cases are actually outside the state of Colorado. Auto Owners is involved in a lot of litigation. American Family historically has been involved in a lot of litigation. And so a lot of these cases regarding late notice in Colorado are in the federal district court. And unfortunately for policyholders and attorneys, there's actually a split as to what rule applies in the state of Colorado. And it depends on what judge you actually get. Judge Krieger issued an opinion about 1.5 years ago that adopted the notice prejudice rule. But then other judges, including like a Judge Martinez and different judges, have adopted the traditional rule of late notice. In fact, Judge Martinez has actually issued one opinion where it was traditional late notice, and then he came back and said, you know what, it's a state court decision, we're gonna let the state courts determine this. So in Colorado, it's actually undecided, which makes it very difficult because of the number of hailstorm claims that we deal with, which we can discuss more next week. But another common question that we get is in Colorado, can we limit the statute of limitations? And the answer is yes and no. So Colorado has a 3-year statute.
The answer is yes and no.
No. So in residential claims, they cannot limit the statute from 3 years. So if you have 3 years to file a lawsuit for residential claims for breach of contract. On commercial policies, they can limit the 3-year statute, right? So then that begs the next question, Chip, is I've got a townhome claim, or I've got a homeowners association claim, where I have residents living in these buildings. Can the insurance company limit my 3-year period to file a lawsuit because they called me at 2 years in, and now we need to file a lawsuit, okay, because the insurance company's not paying. And so, Chip, the case is the Pinewood Townhome Association versus, again, Auto Owners Insurance Company. Not a surprise that Auto Owners is involved. And the court decided that because it's a commercial policy, an HOA policy, a townhome policy, then it does not qualify where it would be a residential exception under the 3-year statute rule, right? So because it's a commercial policy.
Actually, most people, this is crazy, I mean, and it varies from state to state, but a lot of people consider condominium policies to be commercial/residential policies, neither, you know, sort of a hybrid both between residential as well as commercial, but.
Yeah, so the case, you know, it came out 2017, and the reasoning behind it is that, look, it's a commercial policy. That was the key factor, that the policy that was issued is a commercial policy, and because it's a commercial policy, the insurance company, Auto Owners, could limit the 3-year statute in Colorado and bar claims.
And so, I'm gonna give you, so this is Chip Merlin now speaking, because again, safe is better than sorry. If you're a policyholder, if you're a property manager of one of these condominiums, if you're a public adjuster, if you're a contractor, if you're anybody has one of these claims in Colorado, and from what he's saying right here, read that policy and see when everything is required to be done. And what, for heaven's sake, whatever you do, don't go beyond that. And you may want to call an attorney if there's any delay whatsoever in the payment of the claim or any aspect with respect to the claim. Indeed, even in Colorado has bad faith actions, statute of limitations can.
And that's not barred by the 3-year period either way.
But,
so that's from the date it accrues.
Date it accrued, but there's a statute of limitations for bad faith claims in Colorado as well, too.
Yeah, so it's 2 years from the
yeah.
date that it accrues. And so that's where you can extend that period of time, because if the insurance company denies the claim 1 day after the 3-year period, but they should have paid the claim, we've actually brought bad faith actions if they're independent cause of action, which I don't want to get too much into, than just a breach of contract. And so depending on your jurisdiction, you can bring independent tort actions, irregardless of finding a breach of contract. Other jurisdictions, you have to have a first finding of a breach of contract.
So I guess
yeah,
as we're going through our slides here,
we've already talked about
18 and 19
two.
are all Colorado. You know, I love, if you go to 20, I wish this was the law everywhere.
Yeah.
You know, Arizona is almost got a public policy, if you read some of the case law, that the insurance policies are written by the insurance carriers. They're written for a purpose just for them, and these what they call arbitrary dates that the insurance companies pick to select, you know, should stop the insurance company from doing what the product's supposed to do anyway, and that's pay for coverage. And so, you know, unless there's some, you know, showing of prejudice that's, you know, happened to the insurance company with respect to almost any dates, you know, we're not gonna allow the insurance company to skirt the fact that they owe money. Now, again, that doesn't mean everybody in Arizona should wait forever to do these things. As indeed, what I would suggest is you keep doing them as promptly as possible, because again, that's the safest thing to go do. But you do have situations, we had a major hailstorm claims there in 2010.
So the case
and we were bringing claims.
Right.
People weren't getting up on the roof for 4 years there, but there was no other hail damage there until afterwards. You see these big holes and stuff like that. You know, hey, really? Yeah, I mean, just think about it. If there was no other hail damage claims, and you see it, there wasn't any before, because in most parts, a lot of parts of Arizona, there just aren't these major hail damage claims. Why does it matter? So
I actually cited to a case that me and my team handled here out of Tampa with some help from our Arizona office. And we actually we had a case where the insured reported the claim to the public adjuster about 3 years after the claim in 2013, 2014. This was the big 2010 loss. We actually filed the lawsuit in 2017. So 7 years after the date of loss. And Philadelphia moved for summary judgment on a late notice defense. And our position, the court agreed with us, was that the damages were minimal at the time. They were not known to the insured. And that the fact that they had inspections that the contractors did not bring to their attention of the loss until about 3 years into it, then that made sense under those circumstances to reject the summary judgment on those grounds. Now, of course, Arizona, like you said, the insurance company has to bear the burden to prove both late notice and prejudice. And given the fact that there wasn't no hailstorm, we argued there was no prejudice. And the fact that we didn't have substantial leaking that occurred in that time period, we argued that it did not increase the damages. So because there was clear evidence of hail damage, we were able to defeat that summary judgment.
But again, I think if, because we're all over the United States, Arizona, in my opinion, is probably the most liberal of the various jurisdictions in not enforcing these timeframes because of their public policies announced in their common law case law, on this, despite the fact whatever the policy language might say, other states are much more stringent than this. So again, a word to the wise, be safe rather than sorry, do things sooner than later. If you're a public adjuster, boy, don't wait, don't think, oh, I'm gonna, there's no prejudice or anything like that. You never know when the prejudice is gonna happen. Take care of things quicker rather than later. So we're gonna move on to the proof of loss, and this is number 21, where I talk about it. And
this is Corey's blog.
And this
you're
is
talking
Corey,
about on
because
Friday,
Corey
yeah.
did right. Corey, again, 11 years ago. Some people just start writing these blogs and they say they're experts. We've been doing it for 15 years now. And Corey wrote a 12-part series, and we're starting this on this Friday at 2 o'clock and go for the next 4 Fridays, are all just nothing about proofs of loss, and try to get it away from some of the myths of the proof of loss. But we're going to start from the very basics all the way through, and I think it'll be a good educational purpose. But for proofs of loss, read the full policy. And if you're not reading the policy, that F turns into something else, as Larry knows when I yell at him for not reading the full policy. He just assumes he knows everything, and he really doesn't, because I said, did you read the policy? And he looks at his mouth goes open. And
Yeah, because that happens all the time. Absolutely.
because reading the policy is a pain in the neck. It really is. And you got to start from the very beginning and read all the way through, even on proofs of loss. And
Well, one of the big things is a proof of loss affirmatively required, like the State Farm typical.
well, we're going to
HO3.
get to that.
All right, well.
You're jumping ahead of me.
Well, hurry
So
up,
if
read
we
the
go to the
policy.
next thing, you typically have 2 different types of proofs of loss in terms of time requirements. And so we go to the next slide, I guess that's 26, and you have a 30-day proof of loss. Some are a 60-day proof of loss. And then it's 30 or 60 days after what? That's the next slide. And it's, is it when the insurance company requests it? Because you'll find we have request policies, which are becoming much more common. And then the others are, after the loss.
So what
Yeah.
explain that? Yeah.
So if you have a date of loss policy, or after the date of loss policy, an insurance policy and the conditions might say 30 days after a loss, you have to submit to us, or within 30 days after a loss, you have to submit to us a sworn statement and proof of loss, which contains the following. And then it goes through and it tells everything that you have to have in the proof of loss.
So it doesn't say based on a request.
Right. Whereas the other ones that say 30 or 60 days after we request, or it could start after we request, comma, 30 or 60 days, after the request, you're gonna provide us a proof of loss, and then you gotta put all these, whatever it says you have to put in the proof of loss. Sometimes they say, we'll give you a form for what you have to fill out for what the proof of loss is, but Corey, I said, we'll call Corey an expert in proofs of loss, and then Corey started going crazy saying, you can't call an attorney an expert in the field of law. And I said, why not? He says, well, Mary's gonna get mad at you because the bar, he's saying, well, you are an expert in this area, you studied the heck out of it. And he says, no. I said, what, you just specialize in proofs of loss? I says, I think it says you can't say you're a specialist in insurance law, but I think Corey's an expert in proofs of loss. If somebody wants to turn me into the bar, we'll argue about it. And he's pretty dadgum good about knowing what proofs of loss are, and that's why I'm bringing him in next to me. Not to say you're not good at it, Larry, but the truth of the matter is you didn't write a 12-part series on proofs of loss and been keeping
So,
up.
can I request an extension? Sometimes I have cases, Chip, where I've got a lot of issues, they're moving targets, multiple buildings, hard to get a re-inspection or inspection of the property, and the insurance company says, I've got 30 days to do this. Can I request an extension?
You can always request an extension. Is it gonna work is the real question if you ask the extension and they say no. And then you got a requirement that you gotta go do it.
Right.
And again, that might be state by state. In Arizona, an insurance company would be crazy not to give you an extension because they've already said the public policy is these are arbitrary dates. And so long as there's no prejudice and you explain what it is
Right.
and why you need the extension, but literally, if you get to a national flood proof of loss,
You're done.
you're done. As a matter of fact, that's kind of what stuck this out. I love you, Cal Spoon and Melanie. Y'all doing great, coaching up with all kinds of public adjusters. But whoever started on the proof of loss saying you don't have to notarize a proof of loss, there's a lot of exceptions to that. One is there were some attorneys going around saying, oh, the federal regulations that came out by FEMA says you don't have to notarize a proof of loss.
Yeah, no.
You know what a federal court said about that? You can't rely upon what a governmental agency says what the law is. Everybody knows what the law is, and if the law says you have to have a notarized proof of loss, you gotta file a notarized proof of loss. You're out for a stupid technicality. Now, I think that's wrong, and Congress ought to change the law, but they haven't done so yet. I mean, and so the federal government, through FEMA, through their judges, through their attorneys, we ought to whip those attorneys because they're really not doing anything for the public good. I probably shouldn't say it that way. We should change the law because it's not for the public good, and we ought to get to our Congress people with respect to floodplains, because it's not right that the government, is, can I say what the government, I better be careful here. For the government not coming through on its promise to provide insurance benefits and getting out on loopholes is really anti-American. Is that fair?
That's fair. We gotta keep moving.
So we'll talk about proofs of law starting on Friday.
Yeah, I'll let you
It just drives me nuts on federal, and so, and it drives everybody nuts.
Well, it's just impractical that after a flood loss, you can even get an estimate after a hurricane for 30 days or after a hailstorm for 30 days. Sometimes they can't even get a contractor out to the property. It's ridiculous.
So if you have a flood loss claim under national flood insurance policy, it's a whole different area of the law. It's not state law, it's federal law, it's very different. Enough said on that. So repair times, we're gonna talk about repair times, not today.
Yeah.
I'm gonna briefly talk about them, not next week, because we're gonna go into hail damage states, and then we're gonna go into hurricane states, but there are certain provisions within the insurance policy that give you only so many days to make replacement. Most insurance policies say that you gotta do replacement as soon as practically possible, or as soon as possible, or promptly.
180
Some
days.
provide, and no later than 180 days.
2 years.
That you have 180 days to do all the replacement for all your personal property. That you have 2 years to do a replacement in order to get your code 8 grade coverage, but you can ask us for an extension in writing. It doesn't give what the explanation is why the insurance company say yes or no, but it says you can ask for it.
Right.
It's kind of weird. I guess they're supposed to do it in good faith like you do everything in insurance contracts and everything in contracts anyway. And we all know that all insurance companies act in good faith. All you have to do is read, pay up. And you'll see all kinds of instances of insurance companies, like that one insurance company had the Jewish lawyers list. That was really in good faith, and they'd be surprised the stuff that's in that book.
Chapter 7 is not my case.
Page 60, what was it? 69, right? 89?
87. Yeah.
Larry's the page 87 person with John Bukowski.
Yeah, I think that was a $2 million bad faith.
Larry's finally mentioned in a book.
Yeah. It's actually a second book, but the other one is nowhere near as good as yours.
There you
All
go.
right, so moving on. All right, so the next slide is, can a policy shorten time can a policy shorten the time frame to file a lawsuit?
For file lawsuits. Now we're gonna talk about statute of limitations, because we need to talk about statute of
So
limitations.
first, what is a statute of limitations?
Statute of limitations prevents somebody from filing a lawsuit against another party unless they do so within a certain time frame. And this
So if I'm 100% right, but I wait too long, I don't have a claim?
well, you have a claim, but if you file a lawsuit, you can lose the lawsuit unless they say we don't care.
Right.
And you know how insurance companies are. Let's see, do we care, do we not care? We can save $2 million or pay zero.
So let me give you an example of that. So there are, so in the jurisdictions that actually allow the insurance company to restrict the statutory limitation period by contract. So a lot of people confuse a contractual limitation period versus a statutory limitation period. Statute's the law. Law says 5 years. Policy says 1 year, okay? Like at Oklahoma, for example, the insurance companies can limit by contract the time to file a lawsuit versus the statute, all right? Now, here's what's important. The regulators have required the insurance companies, if they're going to actually hold the insured to that limitation, to actually put that in their correspondence.
Well, that's some, not all.
No, but some do. In Oklahoma,
Some
you
do,
have to. Well,
but-
that's why that's important. But going back
but
to your
not
point,
all.
Going back to your point about
And as a matter of
the-
fact, it's a few statutes and regulatory bodies actually require the insurance company to provide that notice in advance. And so
Yeah.
I think that the right thing to say on statute of limitations, every single state has a contract statute of limitations. By a written contract, which an insurance policy is, you have to file a lawsuit. In Florida, it's like 5 years.
Yep.
And so all of a sudden, if somebody writes, we're gonna make it 2 years.
It's not enforceable
Can they
in
do
Florida.
that in the state of Florida? Not in Florida,
Right.
but in some states, they can shorten it. And then the question is, how much can they shorten it? Some states say, so long as it's reasonable. And the case law then comes back and says, well, reasonable is not less than a year. Some have said,
6
yeah,
months.
you can do it to a year, you can do it less than that, maybe, it depends on the circumstances. And so you gotta be very careful, and so, every single state has a different statute of limitation, every single state applies a different rule to it, and like is their tolling, which we get to, what's this slide, number 30?
Yes.
Do you wanna describe tolling, or you want me to
Yeah,
describe
I'll
tolling?
describe tolling. So tolling, there's two different types of tolling. You have statutory tolling and you have equitable tolling. Okay, statutory tolling means there's a law that takes effect that actually tolls the time period for a statute of limitations. The best example is in the state of Illinois. So in section 143.1, I believe, there is a statutory tolling period that as soon as the insured submits a proof of loss, okay, that it stops, it freezes the time for the insured during the investigation of the claim and until the insurance company makes a coverage decision to when the policyholder can file a lawsuit. Now, why is that so important? Well, in Illinois, Chip, it's one of those jurisdictions that allows the policy to limit the statutory period of time. So under section 143.1, once a proof of loss is submitted, now that time stops. So if my hailstorm is January 1st, I file a proof of loss on February 1st, I have 11 more months after the carrier makes the coverage decision to file my lawsuit, so effectively 2 years. Then you have other jurisdictions that allow for equitable tolling, which takes the same legal concepts of statutory tolling, but apply it based on common sense and reasonability, right? So, for example, if you've got a 1-year limitation, but the insurance company is continually adjusting the claim, I don't want to say leading you on, but hey, we're gonna consider this. Here's a supplemental payment 11 months after the adjustment of the claim, or the denial of the claim. The courts can review that and make a decision that it was effectively told because, and usually the language is something like this, Chip, it's, there wouldn't be a reason the insured would have filed a lawsuit because the conduct of the parties was still moving towards a resolution.
And you have to be careful on that, because some of the states then come back and say tolling applies until there is a full or partial denial of the claim. And so what happens is in some jurisdictions you get part of the claim denied, but you keep talking about the rest of it, and next thing you know, the time to file that lawsuit is passed because there's been a partial denial of the claim. National flood insurance kind of works that way in essence, but it actually reads that way in the statute itself, so that a partial denial of a national flood insurance claim triggers the 1-year time frame for you to file a lawsuit for the entire claim in the district court, federal district court, where the flood actually happened. But tolling is important. It can delay things for, essentially Florida has a tolling statute. If you think about it, after a fire claim, you could go for a number of years to file a proof of loss, then the claim could get denied in the 4th year. You then have 5 years after that to file a lawsuit for a fire claim. You know, that's an effective tolling until there's been a denial of the claim, which would then trigger, because that's when the statute of limitations actually starts to run in the state of Florida from the denial of the claim.
You already hit on that.
And I already hit on the partial denial again. It's every state. So does it change state law? The first thing to do is read the policy. Mm-hmm. Everybody thinks, oh, Florida's got a statute of limitations of 5 years to file. Okay, that's great. Read the policy. Why do you read the policy? And we'll talk about that. Even in the state of Florida, where it's against public policy to shorten it, there are some things in some policies I share where that can come back and haunt you now. And some states read what the policy says. If it's 1 year, it's going to be 1 year. If it says it's going to be 6 months, it might be 6 months. The case law might say it's 1 year. It might be 1 year in a day.
Or in Colorado, if it's a residential policy, you can't reduce it. If it's a commercial policy, you can. So that's why, Chip kind of made a joke to me before we started today regarding these intricacies of what we do. And he's getting his guides out, because if you don't practice this type of law exclusively, it's impossible to understand the actual details.
We produce these for public adjusters, who are typically the people that are licensed in the various states to go represent policyholders, and so we make a Merlin guide for a lot of the states. Here's one for New York, here's one for Illinois, here's one for California, this one's for Colorado, we have them for Arizona and Florida and a number of other states as well too, that helps spell out these particular rules depending upon where you might be practicing public adjusting. But these things work for contractors and policyholders as well too. If you'd like to get one of those, just let me know, and we can get these sent off to you and, or emailed to you and things like that. Is somebody asking a question?
Yeah, I think it's a good question. I don't wanna wait, so we may not be able to come back to it. It's from, Jan Miller. If the insurer requests a sworn statement and proof of loss and is supposed to furnish you with the document, is the demand for the proof of loss null and void if they don't furnish you with the document? I would say you need to request the document.
Well, that's a great question.
Yeah, it is.
So, yeah, because, that's a heck of a great question, because you don't have the documents, and many of the states, they indicate that and these are found typically in the regulations issued by the Departments of Insurance. Most states say within 10 days, within whatever it might be, even if the policyholder asks for it, the insurance company has to provide the forms necessary for making what the claim is. Some states, like, North Carolina, give the insurance company so much time, and if they don't do so, those form requirements are just waived. You can put it on anything that you would like to. I often say, read the policy, because many times in the policy it says, after so many days, please provide us a sworn statement of proof of loss. In the proof of loss, it provides, you are gonna provide the following. So if it says we're gonna provide the form, they don't provide the form to you, how can you make it up? But if it does say in the policy what you're supposed to put down, Jan, you put those things down, and I had my client go swear to it. We had an insurance company one time, I was so upset with, I can't say who the insurance company is because I think we settled confidentially. It was for a mansion that was in Biloxi or Gulfport, Mississippi after Hurricane Katrina. It was a high-end mansion, and the insurance company was a high-end insurance company. And it said to, provide a sworn statement of proof of loss, and this is what we were supposed to provide. Nowhere in the proof of loss did it say that we had to provide what the actual claim amount was. They didn't want to know that. It's not in the insurance policy. That was left blank. It's nothing there. So they gave us a proof of loss. Hey, fill out this proof of loss, but and it had the claim amount. Really? We didn't have to put the claim amount for the personal property or the mansion in the insurance policy, but the form we got was there. I was so upset with them by this time, and so we filed a lawsuit to say they provided us and required us to file an improper proof of loss. And it kind of went downhill from the insurance company after that as we started to do the facts, and it all got settled confidentially. But again, I tell people, read the full policy to see what you're required to do. If an insurance company is supposed to provide you the form and they don't provide you the form.
Yeah, so Jan, to put it really short and sweet, I wouldn't want to be the defense attorney arguing that the insurance company denied a claim if the policy says they have to provide you the form and they never provided the client the form. I would not want to be in that
and
position.
the law of Louisiana is such that they don't provide them the information or the form and stuff like that. You merely have to tell them where to go take a look at what the loss is. And so it's, in that state, for that, it's actually very broad. And there's a lot of bad faith brought because of the form element in the insurance company pretending that they don't know what the loss is, and they're not out determining what it is.
Well, the whole thing is BS, because if you provide them the estimate, there's two things that require a proof of loss: notice of the claim, which they obviously have, and then number two, what the insured is claiming.
Well, but not all proofs of loss even say that.
Right.
Because they also want to know is who else has an interest in it. Are there any other insurance policies out there? And there could be other insurance policies. There could be other interests, like the lien holders. What's your interest in? Do you own the property or not? And if you go back historically where these proofs of loss came from, it's a lot different today than it was, 250 years ago. If you're living out in Missouri along the Mississippi
Who owns
River,
the building?
and
Right.
your place goes down, you send them proof of loss, and that's
a good point, yeah.
And in those days, it wasn't an insurance adjuster who would do it. Most of the time, it's the actual insurance agent who's selling the policy to them. So they want something notarized, sworn to, that they can rely upon for the person that's out there. So, historically, there's some changes that have gone on, and we haven't, kept up with it, because it is kind of ridiculous to have these meaningless pieces of paper if the insurance company already knows everything that's there, and you sent them the estimates and stuff like that.
No, I've never made the argument that it's actually archaic. That's pretty good.
Well, it is.
You actually
Well, it is,
understand
but if you understand where
the form.
you got to read all those books back
Right,
there that I keep
right.
collecting from wherever the ruck tracks down from me. And we'll go over this with Corey.
So slide 33, does appraisal toll the statute of limitations?
And in some jurisdictions it does, and in some jurisdictions
It does not.
it doesn't. To me, I mean, that is a big trap for public adjusters, contractors, policyholders, attorneys that are asking for appraisal. It goes all the way through. You get the appraisal award, the insurance company goes,
Yeah, see ya.
hey, good, now go try to enforce it, you know?
So what
Talk
do you
about
do?
bad faith.
You get a tolling agreement. If you're,
Yeah,
if you're in a statute, if you're in a state that says 1 year or 2 year, if your the standard ISO policy, AIS policy is 2 year limitation period, right? So if you're in those jurisdictions and you've worked with the carrier and you're coming on that 2 years during the appraisal process, you get a tolling agreement executed so that you protect your client's rights.
And that's what we talk about in slide
That's the next slide.
34.
All right, so now we're gonna get into, we're pretty much finished now.
Yeah,
but
because we're talking about, but that's the Merlin guides that I brought out for the statute of limitations, but also statute of limitations, George, you can put it down on our blog, and most of the time these things are to come up. Next week, we're gonna be talking about the notices of loss specifically in what we think are the hail damage, you know, states as well as the hurricane states.
I got some questions too.
Oh, you got some questions?
I
Let's
do.
go
I
through
got
this.
some good questions. Lee Walters.
God, it's hard to believe, 51 minutes.
Yeah, you don't stop talking.
Well,
so-
it feels like we just started.
I know.
They're supposed to be only go on for 30 minutes.
We
And
have not had a single one of these. go
Usually it's because of
30
you.
Yes, my fault. It's always my fault. So Lee Walters asked Chip, does the proof of loss time clock start after we receive the certified policy? The answer is no.
No.
It's no, I get where he's coming from because you may not know what the requirements are in the certified policy, and you're really hitting on a good point, Lee. Most of these policyholders don't even have a copy of their policy laying around for you to review.
Well, think
So
about it.
you don't know.
If it's flooded out, blown away, or
Right.
burned up, it
Right.
might be how you don't have you don't have your policy.
Yeah. So here's going from Jason and Jason.
But the answer is no.
No, it starts from the loss, or upon the request, based on the policy language which we talked about. So Jason, I do not know how to pronounce your last name. It's Chara? You know it?
Why don't you try a couple more times and
No.
butcher it some more?
I'm sorry, Mr. Jason. It says, in the event that the carrier delays or refuses to promptly provide a certified or any policy in the states that you practice, does that change the drop dead date for the proof of loss? No, I think it's the same answer. The proof of loss is due either when they provide you the form upon their request or affirmatively where there's no requirement for requesting at all. It's triggered by the loss.
That would be really interesting. Hey, my house burned down. I don't have a policy. It burned up there.
So I didn't know.
I mean, we have this problem after major catastrophes, after hurricanes, because a lot of times the agent's offices get all flooded out as well too. And it's not, I say it shouldn't be this way because a lot of the major insurance companies, you can call them up today, you can report the loss, you know, on the internet, you know, things have changed that way, and most of the companies give it to you. I know if you're a public adjuster, oh, we're dealing with a public adjuster, and they treat you differently. I have no idea why. If you're a policyholder, they treat you one way, hire a public adjuster, no, we aren't giving you anything. I mean, but the truth of the matter is you should be getting down and at least getting the declaration page. If you get the declaration page, a lot of times I have the form, you can look up the form, and you'll know what it says regardless if you got the certified, you know, copy or not, because most of the time these are general forms. They're being, you know, promulgated, and then make sure you know what the regulations are, statute. If this happens to you and an insurance company's not telling you what the date is, they're hiding the policy form, my God, make a complaint to the Department of Insurance. The Department of Insurance, and to the extent we know that some departments of insurance are watching this at their level, you know, you guys should be having market conduct studies against any insurance company who would do that. If they would not give a copy of the policy, you know, to somebody who doesn't have it so they know what these time deadlines are, how bad of an insurance company is that?
It's embarrassing.
But it goes on.
It's embarrassing Arkansas has to come out with a bulletin that's issued to every insurance company in Arkansas because the Department of Insurance identifies a business practice that's improper. I mean, it's ridiculous. So the last two things that I want to finish up with, number one is we have about 10 more slides that include blogs, include articles, some case law if you're interested in it, that kind of summarizes the positions that we've taken. A lot of the stuff that I've kind of referenced today is in these links. Because these documents are so important, if you could, just go ahead and hit share on your link there of the discussion today so that more people can access this stuff and we can continue on. When you share this, it really does help get these documents out there and these bulletins that will help all policyholders. That's obviously the goal of why we're having these discussions. So
I think a lot of times if you call the customer's insurance agent, the person who sold the insurance policy, I want to get back to that last question. You know, the agent wants to help out. They want to help the customer get it paid. Great agents are out there, you know, all the time. They want to help. They want to be an advocate for their customer afterwards. You know, they want to show that their value, and a lot of times if the insurance company's not gonna do it, they're gonna tell you what the form is, what the deck page is. Not all the time, not all the time, but at least you should be able to get something. We recently had an agent that would provide the deck page but wouldn't provide the policy. I started, since the client didn't have a copy of the policy but only the deck page, I wonder if the agent only sent them the declaration page and they never had the policy to begin with, which is a whole nother issue, out there. But are there any other questions out there, Megan? Or we have another question?
Yeah.
We got couple more minutes, 5 more minutes.
I think we do one more. Let's see here.
All right.
Megan's got some.
Does the POL time clock start after we receive the certified policy?
Nope, I think we hit that one.
Yeah.
Yep, I think, and Tony's saying, obviously Tony Rugas has a lot to add regarding the proof of losses. He appreciates the fact that we're going over that. I think we've hit all the questions.
What, you gotta, hey, Tony, if you have all that to say, you ought to come on Friday and see if you can stump Corey, who I've just said is an expert. Although, I don't supposed to say he's an expert according to Corey, because he's afraid of bar rules. See, the bar rules say that attorneys don't supposed to say that they're experts or specialize in anything. Instead, it's supposed to be, oh, we can tell you we limit our practice to the field of insurance law. We don't do, you tell me the difference now, but that's what the bar ethics rules are, so
we're gonna
Corey
comply.
limits his practice to that of insurance law, and he does limit most of it to property insurance law, here in the United States.
So one more time, what we talk about next week before we wrap up?
So next week, one more last time, if you are in an area where you have a lot of hail damage, or if you're in an area where there is hurricanes, or if you go there, you don't want to miss what we have to talk about next week, because we think it means so much state specific regarding notices of loss and statute of limitations. We're going to be talking about that next Tuesday at 2 o'clock. So thank you very much. Had a great week, great discussion with you. Larry, even a great discussion with you.
Thank you. Please hit share.